Welcome back to The Verdict, a podcast brought to you by Millick Insurance Company. I'm your host, Tammy Smeltz. Today's episode is a little different. Instead of our usual format, we're bringing you a special presentation from the Medical Society of the State of New York's CME Day. In this session, Millick's Vice President and Managing Attorney, Nancy May Skinner, shares important insights on the Medical Aid in Dying Act, an evolving topic with significant legal, ethical, and clinical considerations for healthcare professionals. We are pleased to share this valuable discussion with you. Let's get started.
The Medical Aid in Dying Act, MAID. It amended the Public Health Law 2899D. Starts with D, which is the definitions. And it was just February that Governor Hochul signed the Medical Aid in Dying Act to become effective in August. In the broadest of terms, the act allows qualified individuals, which are essentially New York patients. This can't be offered to patients who are outside the state, to request a prescription from their attending physician, also defined by the statute, also has to be licensed and practicing in New York, for self-administered medication, meaning the patient gives this medication to themselves, which will bring about their death. The statute is limited to patients who are terminally ill, and the definition of terminally ill in the statute is an incurable, irreversible condition or illness that will cause death within 6 months, or with or without treatment. So it's fairly limited, and there are a lot of safeguards to make sure that it's used appropriately. So it contains safeguards both on how the patient requests it, and then how the attending physician examines and approves it, including the involvement of 2 other medical professionals before a determination will be made that a prescription will be issued to the patient. So the patient's request for the medication, for a prescription, has to be both oral and written. So this is very unusual. The oral request needs to be tape recorded or videotaped, and that needs to be placed in the patient's medical record and retained in the patient's medical record. So if there's ever someone looking back at it, that needs to be in the record. There is an alternative if the patient is unable to speak, but that's only for physical incapability. So it starts with that oral request, and then there's also a written request. And the written request can't be made until there's a showing that the patient's an appropriate patient to self-administer the medication. So are they capable of administering the medication to themselves? Do they have that terminal illness or condition, as determined both by the attending physician, and referral will then be made if the attending physician finds all of the criteria are met. The patient will then be referred to a consulting physician who will make an independent determination of those same things. And then a request can be made by the patient as long as it's an informed decision, also a term that's defined by the statute, where the patient requests the medication and has to say, this is of my own volition, no one is coercing me to do this, and I would like to obtain this medication for the purpose of ending my life. So some requirements for that written request is that there are 2 adult witnesses, at least 2 adult witnesses. So the 2 adults cannot be related to the patient, cannot be a spouse or domestic partner of the patient. The 2 witnesses cannot be, they cannot stand to benefit from the death of the patient. So if they were going to inherit either through the laws of intestacy or through a will, they could not be a witness. They cannot be a treating physician or someone who's providing medical care where the patient is currently being treated. And they cannot be the agent under a healthcare proxy or other advanced planning, estate planning document. And they must make that determination themselves and state that determination themselves, that the patient that they're witnessing signed the document is making this decision of their own volition and has expressed that to them. The three providers who are involved in making the determination that the prescription will be permitted to be given to the patient, the attending physician, the consulting physician, and the mental health professional also cannot be witnesses. So it's a process. There are forms available by statute in 2899K that can be used, don't have to be used, but sort of safe to use them because you'll have dotted all the I's and crossed all the T's, and there are a lot of those in this legislation, but it's not required that those be used. Just that their substantive content, be utilized. So there's no presumption that someone is an appropriate candidate for MAID based on age or disability. It really comes down to these determinations that need to be made as part of the process. So a qualified individual needs to make the request. This is not something where a healthcare proxy can make the request, a power of attorney can't make the request, and this can't be made in a MOLST or another advanced healthcare directive. It needs to be made, verbally and in writing to the attending physician. If an interpreter is needed, reckoning back to our last presentation, there is a form also for that in Public Health Law 2899K. So the patient has to meet the statutory requirements, and that requires the attending physician to go through a series of steps. So the first one is an in-person examination, and that can be waived, but only if the physician determines within a reasonable medical judgment that requiring the patient to come in for an in-person visit would result in extraordinary hardship to the patient. So basically, extraordinary hardship means, coming in for an in-person examination would cause undue pain and suffering, necessitate extraordinary expense, a huge logistical burden with the transportation or however. And if that finding is made, the physician can waive the in-person examination and do a telehealth examination. That needs to be documented, of course. So the attending physician first makes a determination that the patient has a terminal illness or condition, which we talked about, that the patient has decision-making capacity, that they understand the decision they're making and they're able to make that decision. They've made an informed decision, meaning the physician has made all of the disclosures that we'll talk about in a minute, and that the request is voluntary. So obviously, who's present with the physician or with the patient when the physician is speaking to them? Does it appear that they're being pressured to make this decision? These are all things that factor in. Then the attending physician must inform the patient of a second requirement that after the attending physician believes the patient to be an appropriate candidate for MAID, they must be examined by a consulting physician, and the attending physician will refer the patient to that consulting physician if they would like them to, and that consulting physician needs to go through the same process that the attending physician did to make an independent determination that they also believe that the patient is an appropriate candidate. Once those two things happen, the patient will be informed of the third requirement, which is confirmation by a mental health professional. That can be a psychologist or a psychiatrist. And the patient is referred, and on the patient's request, to that mental health professional who will determine decision-making capacity. And decision-making capacity is one of the requirements before the prescription will be provided. And then last, the physicians are required to offer the patient information about counseling or refer them for counseling as part of the process. So what is an informed decision by the patient? It's one made after a discussion with the attending physician regarding the patient's medical diagnosis and prognosis, that they have a terminal condition, that their prognosis is not to live more than 6 months, the potential risks and probable outcomes of taking the medication. Well, we know that the medication is intended to end the patient's life, but what are the risks of the medication? A typical informed consent risk benefit alternative discussion. And then the physician needs to advise the patient that it's possible they may choose to obtain the medication, but then not take it. And that's fine. The physician needs to discuss alternatives and appropriate treatment options. So The patient could avail themselves of palliative care, of hospice, of pain management. This isn't the only option, in other words, and provide documents that have been created by the Public Health Department about these other treatment options, including palliative care. Okay, so some other things that the attending physician is required to discuss with the patient are the importance of having another person present when the patient takes the medication, because obviously we know what the outcome is to be. So it's not only important that that be a part of the conversation, but that and all these other elements be well documented in the record. No person other than the patient themselves may administer the medication. The statute calls for self-administration. So if the patient can't take the medication themselves, then they're not a candidate for MAID. And then that the patient should not take medication in a place because of the intended outcome. It's recommended that they either take it at home or within the healthcare facility where they are residing, and that the patient should inform their family of their decision to request the medication, and that taking the medication will end the patient's life. Now, this is not a precondition to getting the prescription. It is still possible for the patient to get the prescription. They decline to or are unable to notify the family, but it is a requirement that the physician advise the patient that it's advisable to do this. There's also a waiting period before the prescription can be filled. So you can see there's just like step after step of safeguards to make sure that this is used appropriately and it's well considered. So the waiting period is 5 days from the time that it's written, and the prescription should document that it's written, the date that it's fillable. There is an exception if the attending physician does not believe that the patient is going to last 5 days. They can make a determination with reasonable medical judgment that the patient may die before the expiration of the waiting period, and therefore that fillable date is sooner than 5 days. The opportunity to rescind is something that really needs to be very clear to the patient, and it's easier to rescind than it is to get the patient. So the opportunity to rescind must be offered with the prescription, and the patient's request to rescind, if made, can be made at any time in any manner. There's no, verbal and written. It's anytime, any manner, and there's no showing required that the patient has decision-making capacity. So we really are doing everything we can to, in the statute to give the patient every opportunity to rescind. Documentation is important with this legislation, as it is always, right? That is the word that a jury will see if there's ever a medical malpractice case. That's the black and white document that's created at the time that treatment is provided, and it is very good evidence of what took place. So it's your best defense, absolutely your best defense in this situation and in any other. So the medical should document the date of the oral requests for the medication and the written request for the medication, including that, evidence of witnesses. The attending physician should document the diagnosis and prognosis, terminal, 6 months, the determination of decision-making capacity that was made by a mental health care provider at the referral of the attending physician, that the determination made by the attending physician that the patient's acting voluntarily of the patient's own volition without coercion, and they made an informed decision, meaning the physician told them all the things they need to tell them and the patient still wanted to move forward. And then that written determination of the decision-making capacity will come in through the mental health provider, the psychiatrist or the psychologist. Then the attending physician confirms all requirements have been met for the statute. Medication can be prescribed. So one important element is that the law provides that the death of the patient under these circumstances, under a MAID procedure, is not suicide, and it is not the medication that is given. The death certificate must identify the underlying terminal illness or condition as the cause of death. And this is of contract for law. This is suicide. So if there are limits based on that, this is not considered a suicide. The law does provide that healthcare providers and facilities are not required to participate in MAID. It just asks that be made clear to the patient early on in the process, and that if the patient is interested in MAID and that provider or facility is unwilling to provide them with a option, that they refer them to someone who does participate in the MAID process. So private healthcare facilities, hospitals, can prohibit prescription of MAID for everyone who works there if it is based on a formally adopted policy based on religious or moral convictions. And again, there's that timely notice to the patient and a transfer made elsewhere. The law also provides good faith immunity for participating providers who either participate in MAID or refuse to take action under the statute. So there's immunity whether you ultimately give the prescription or whether you refuse to give the prescription, and that it does cover the risks and benefits discussion, the referral to another provider if you choose not to be a MAID provider, that you were present when the patient self-administered and the patient died as a result of that administration, or you refrained from preventing that administration if you were there with the patient. What immunity does not cover is simple negligence, recklessness, non-compliance with the statute, or intentional misconduct. That's why it's very important to document your compliance with all the elements of the statute so that immunity will kick in. So the bottom line, this is an important compliance statute. Make sure all the I's are dotted and the T's are crossed, then document all of that thoroughly. The statute is limited to New York patients and New York providers. There's the 2 request process. The patient must meet the requirements, first of all, of being terminal and within 6 months of death. Then the 3 providers need to assess the patient independently and document their findings. And then the prescription can be at the 5-day period. The good faith immunity is a good opportunity for physicians participating in this to provide the care that the patient is asking for and not expose themselves to liability.
We hope you found this presentation both informative and thought-provoking. A special thank you to Nancy Mae Skinner for sharing her expertise on the Medical Aid in Dying Act and what it means for healthcare professionals in New York. For more risk management or legal resources, be sure to visit milmic.com. Thanks for listening, and we'll be back with more episodes of The Verdict soon. This podcast is for general purposes only and should not be construed as medical or legal advice. This podcast is not comprehensive and does not cover all possible factual circumstances. Because the facts applicable to your situation may vary, or the laws applicable in your jurisdiction may differ, please contact your attorney or other professional advisors for any questions related to legal, medical, dental, or professional obligations, the applicable state or federal laws, or other professional questions.